Hello everyone, welcome to 42 Bedford Rows webinar this evening. This is a webinar run by the Animal Welfare Group, which is a new group set up in Chambers, made up of a number of practitioners from various legal specialisms, all come together to try and start to promote and incorporate into our practices animal welfare. So my name is Marcia Hyde and I'm a family practitioner. Let me introduce the other members of the panel tonight, and then I'll go on to describe to you what we're going to do tonight. First of all, we have Richard Furniss, who is Joint Head of Chambers. Richard is a personal injury practitioner and he specialises in clinical negligence, and he also sits as a coroner. We have Ed, who specialises in civil and criminal law, and he also does a lot of regulatory law, and he's going to talk tonight probably from the criminal perspective. We have Charmaine Clubb, who's also a family practitioner, and she's going to talk about divorce and family finance. And we have Paul Fuller, a new member of Chambers, welcome Paul, who is a business and property specialist, and he's going to talk from a housing and property specialism. We hope also that Katherine will be joining, and she's another specialist in family finance. So today, of course, is World Animal Day, so happy World Animal Day to everyone. And as I say, this is a new practice group in Chambers, and it's our first webinar. And what we wanted to do in the webinar is to indicate and demonstrate how many different areas of law, widespread different types of practices, can highlight animal welfare and be incorporated into our practices. So the way we thought we could do that tonight was to have a group of panelists from the various areas of practice that I've just described and you see. And we'll have a roundtable discussion of maybe about 5 minutes each, and questions and answers, which I'll talk to you about in a moment, around a single topic. And in that way, it helps to bring out and show how different practice areas can incorporate animal welfare. Because we know that animal welfare is not a specific legal discipline. And so there are different ways of introducing it into our practices. So we hope to be having maybe another 5 or 6 webinars this year where we look in more detail at very specific topics. So that's the group. What we were going to look at today started from my work in domestic abuse, and in particular controlling and coercive behaviours, and an idea that came from that about what is an animal and what does it mean in law, and how do different legal disciplines and perspectives see it and treat the animal. So, as I say, we're all going to talk for about 5 minutes. Just some practicalities about the webinar. I think, as everybody knows, 42 Bedford Rows webinars are all recorded and they'll be published on our website. So this one, if you want to watch it again, will probably be available about Thursday. Questions we can take, and if you can look at the bottom of your screen and use the question and answer box. If you've got any questions, type them up with your details and we'll try and answer them as we go along. If not, we'll try and answer them at the end. And if we can't answer them at all, we'll answer them by email in the next few days. So put your contact details there, just so you know that information will be confidential. So that will be private to the group of panelists. So I thought I'd talk very, very briefly about domestic abuse and how animals are seen within domestic abuse. We, of course, have the Domestic Abuse Act in criminal law, which makes domestic abuse an offence, particularly controlling and coercive behaviours an offence. Now, the there was originally guidance from the Home Office under what types of behaviours could constitute controlling and coercive behaviours, which themselves were then a form of domestic abuse. And part of that guidance was threats to harm an animal, the pet, or actual harm to the pet. So from a domestic abuse perspective, the act of the animal abuse is not domestic abuse. What turns that act into domestic abuse is using those acts to control and coerce. So in some ways, the animal really, what is happening to the animal doesn't matter. So it's a tool of coercing and controlling someone. What surprised me when I was looking at that in my work is there's no case law which has as a factual strata animal abuse or threats to harm the animal. And that's surprising, really, because instinctively, I think what we all know, or most of us know, is it's the emotional tie to the animal or the pet that allows the coercion and the control. Without that emotional tie, then you can't control or coerce anyone. So, of course, although harming an animal can be a criminal offence under the Animal Welfare Act, threatening to harm an animal can't be. That's an interesting issue and topic we could talk about. But it was also surprising that there was no case law, because the links from research are very strong between domestic abuse, child abuse, violent behaviours generally, and animal abuse. And I know Ed might talk a little bit about that later on as well. So it's surprising that there is no case law which has a factual strata in family law, as far as I can find, which has harming an animal or threats to harm an animal. Interestingly, the guidance from the Home Office has been updated recently. It's still in draft form, but in addition to harming an animal or threatening to harm an animal, is also now an idea that you could threaten to give the pet away. And that updated guidance was the core idea for this webinar tonight. What does it mean to give an animal away? Who owns it? How do you give it away? What is the status of an animal in law? So that's what we're going to look at tonight from that germ of an idea. It seems to me that that update to the guidance also underscores the emotional ties between animals who we make as part of our family life. For a victim of domestic violence, threatening to take the animal away, the only thing where there is unconditional love and care, is a terrifying thing. And most of the research also shows that a lot of victims of domestic violence don't leave abusive relationships because of fear of what will happen to the family pet or the animal. And of course, for a child to see an animal abused or to suffer domestic abuse or see domestic abuse is now in itself, the child is seen as a victim, because we've known for a very long time the research links to the emotional abuse that happens to children through domestic abuse of any forms is extremely damaging. So what this points to, it seems to me, is in order to, when incorporating evidence about animal welfare into our practices, particularly say in domestic abuse, from my angle of things, of course, we help to protect humans better, but we also help to protect animals as well. It also points to reform of the law. So, for example, in America, in some states in America, domestic abuse can have as part of the its definition animal abuse. So there's a recent case in New York recently where the court decided that abusing an animal could itself constitute domestic abuse. And then that leads to cause of reform for law. Again, in America, in some states in America, animals can be included in a protection order, which is the kind of equivalent to the UK non-molestation order. And that seems to me to be particularly relevant to the updated guidance saying, well, the threat to give the animal away, that would lend itself, wouldn't it, to an order which would prevent the giving away of the animal. So to come back to our core idea tonight about giving the animal away and who owns the animal, that's my perspective from a domestic abuse family law perspective. But I think now Ed was going to talk to us from a more criminal perspective about the same issue from a different angle. So Ed, over to you.
Well, yes, I mean, here we are at the intersection between family law, animal law, and criminal law. And all those topics, of course, are vast in themselves. And following on from what Marcia's just said, I've noticed that there's some research being done in relation to the pandemic. What happened was that this is research which I've discovered being done by the University of West of Scotland. They've done a large research project, and it's still ongoing, I think, but it's exploring the impact of lockdown both on human abuse and animal abuse, and their key findings are summarised in a very short report on their website. But essentially, they've discovered a team of academics have discovered that animals have been used and are being used to intimidate family members to stop them from disclosing their abuse or seeking support. Abusers manipulating the emotional bond between the victim, as Marcia says, and their pet to inflict further emotional harm. Animals being used as post-separation weapons to continue contact after the victim has fled. Children witnessing the abuser harming the household pet, raising concerns for emotional trauma, and animals as coping mechanisms, with pets providing important emotional support. These are all things touched on already by Marcia. Now, firstly, one has to look at, in law, the term pets is not really used. The term animals and of different kinds is used in different statutes. But one must look at the status of animals going back centuries to the common law, and essentially in law, the law of animals and the ownership of animals, which is what we're looking at here in terms of this guidance under this particular criminal offence, that's section 76 of the Serious Crime Act. This is the coercive or controlling or coercive behaviour offence, which carries a maximum penalty of 5 years imprisonment. Under this this guidance, it says using pets to control or coerce a victim, e.g. harming or threatening to harm, or give away pets. Now, giving away pets, then begs the question, firstly, as to what are pets? And secondly, what does it mean to give them away? Now, that in itself, the definition of animals, like I say, is a large topic in law. But I'll just very briefly touch on it. I'll be as brief as I can. How the English law has defined animals. Looking back at the ancient common law, which goes back centuries, the term domestic animals, which is, of course, you might think is just another term for pets, in law, it's regarded as referring to all those domestic or tame animals as by habit or training live in association with man. And an animal which does not exist in a wild state anywhere in the world is in law a domestic animal. And there's an old case about a camel at Chessington Zoo, bit the hand of the man feeding it. I think it's an ancient PI case from 1940. So a common law, domestic animals like personal and movable chattels are the subject of what in law is called absolute property. Domestic animals can be bought, sold, loaned, borrowed, and exchanged. An owner of a domestic animal can bring a claim for conversion, for trespass to goods, under the Torts Interference with Goods Act. It may be that Richard touches on the more of the civil aspect, but like I say, this goes back centuries. This law. There's a case, for example, from 1777 called Binstead and Buck, which is one of the first cases on this, which shows about the ownership of animals. In the case about a pointer dog, which had strayed, and the plaintiff was the owner of that dog, the original owner of that dog, and was able to pursue a case in the ancient remedy of trover to get it back. But of course, we know that animals can be like humans, can be used, abused, enslaved, or abandoned. And there are obviously various statutes, and each statute is a vast topic in itself, designed to protect them. And of course, principally, we have now the Animal Welfare Act 2006, which came into force in England in April 2007, under which a person can be prosecuted for various offences, but one of the principal offences is under Section 4, which is causing an animal unnecessary suffering. And in that statute, it refers to a protected animal. And an animal under the Act means, and has its own definition, it means a vertebrate other than man. So, for example, this Act doesn't protect a pet octopus because and it may be that that is troubling to those who've watched that programme, My Octopus Teacher, on Netflix, but because of course an octopus is an invertebrate. The definition of protected animal under this Act is quite wide. It's an animal is protected if it is of a kind which is commonly domesticated in the British Islands, or it is under the control of man, whether on a permanent or temporary basis, or it is not living in a wild state. And that leads on to another point in ancient English law, which is that the term, as against domestic animals, which are called domiti, you have the concept in English law of wild animals. That's ferae naturae in Latin. And this applies to animals and includes not only those animals which are savage, in the old phrase, or by nature, but also those of more mild or tame nature, which cannot be classed as domestic or tame animals. And domestic animals which have reverted to their wild states are also regarded in law as wild animals. Now, why is that important? Because in law, you can't have absolute property in wild animals while living, and they aren't goods or chattels. So, but there is a qualified, and I can't go into all details in this very, very short talk, if you like, or discussion. But you can have qualified, as you may know, you can have qualified property of certain kinds in animals. So you can have per industriam, by human industry, that's lawfully taking, taming, or reclaiming animals from the wild, and you can have a temporary property in animals. But once they regain their natural liberty, they are not then they revert to their wild state. And then, of course, by reason of their location, you can have property in limited property in animals. So young animals born on someone's land until they can fly or run away, you have limited property rights in those. Rationi in potentiae et loci, that's called. And then, of course, there are all the hunting rights people have over animals, and that in itself is a large topic. So where the owner of land has retained exclusive right to hunt take or kill animals on their own land, they have qualified right to those animals, and also people who have a license to kill or take animals on that land, they then have limited property rights in those animals. So that's in a nutshell the ancient English law on the ownership of animals and rights over animals. But and there's a lot more to be said about that. But for example, under the Theft Act, wild creatures, subsection 4.4, wild creatures, tamed or untamed, are regarded as property, but a person can't steal a wild creature, not tamed, nor ordinarily kept in captivity, or the carcass of any such creature, unless either it's been reduced into possession on behalf of another person, or and possession of it has not since been lost or abandoned. So I suppose I'll stop there, but essentially, if somebody is wanting to give away a pet, it may be necessary under this this offence and in its guidance to decide who it is that actually owns that pet and what rights they have over it. And it may be necessary to look into the law of ownership of animals, which, like I said, dates back centuries. So I'll leave it there for now. I can hand over to Charmaine.
Might be me.
Oh, sorry.
Yeah,
I've
no,
got it
that's
wrong.
fine. We're doing it together. So we're dealing with how animals are treated in divorce, so on separation, and perhaps unsurprisingly, given how much people love their pets, it's believed now that roughly 1 in 4 divorces involves a dispute over a pet. And I think perhaps given that more people have now got pets over lockdown, that could be set to increase. And because of the strength of the emotional connection that people have with their pets, it's often a very hotly contested part of financial remedies applications on divorce. And despite that, as has already been set out by Edmund and Marcia, the approach of English law is to treat the pet, or perhaps more accurately, as Edmund said, the animal, as a chattel or an item of personal property, no different in principle than a painting or a car might be dealt with on divorce. And the result is that instead of looking at how the welfare of the animal might best be met on separation, for example, by continuing to see both parties, or not being separated if there are 2 pets in the household, by not being separated from a pet another animal that they've grown close to. The approach is very much geared towards ascertaining who paid for the animal, who the animal's registered to, and who pays for the insurance. Those are the general lines of inquiries if the court is tasked with making a decision about what happens to a pet when parties separate. What seems clear from the research of case law is that the courts haven't really descended yet into the detail of how one party may continue to have contact with a pet who remains with an ex-partner. So in a way, anything akin to a child arrangements order on separation. And as an example of the sorts of ways that the courts do deal with what happens to pets, there's a High Court decision where the husband and wife jointly own 2 dogs, and the court decided that each party should keep 1 dog, and that any further matters that may arise out of that arrangement should be dealt with outside of court. And that was Mr. Justice Williams. So he very much, I don't want to say washed his hands of it, but it wasn't something that he was prepared to deal with. And he suggested that they place the dispute before a mediator or an arbitrator. And he added perhaps one with experience of dogs. There are ways, though, that the ownership of animals or pets in divorce can have an indirect impact on financial remedy orders. So there's a case where spousal maintenance was awarded to a wife at a level that allowed her to continue paying the high levels of outgoings that she was paying towards the upkeep of 3 horses. And that was on appeal upheld as fair. And so it could be said that reading into that judgment, there is a sort of some kind of eye that's had to those horses keeping the standard of living that they've become accustomed to. But in terms of practicalities, given the courts generally don't defend into the detail of the welfare of the animals at all and approach it as a matter of ownership, in terms of practicalities of what people can do to preempt or deal with the issue of pets on separation, a sensible approach that seems to be taken by many parties is to have a pre or post nup dealing with the issue. We could term it a pet nup, sometimes called, and that can set out then in more detail the agreed arrangements for the pets on separation. And like other aspects of a post or prenup, the family courts would then seek to uphold those agreements unless they were found to be unfair. There are several other caveats that I won't go into, but there is case law on how binding prenups and postnups is, but very simply, if it's fair, the courts will try and abide by it. And as just a very or slightly more light-hearted anecdote, as an example of parties agreeing post-divorce to shared custody, in effect, of their dog of their pets, there's Ant of Ant and Deck. It famously entered into an agreement with his ex-wife to share the custody of their dog, Harley. So clearly it is something that people are perhaps doing more and more in not wanting to simply say goodbye to a pet for forever. There's alternatively mediation, which is what Miss Justice Williams suggested, but I'll leave it there and hand over to Charmaine.
Good evening, everyone. As my colleague Katherine says, although in the eyes of the law, a pet is a chattel, unlike fridges, sofas and paintings, pets are living, they are sentient, and many owners understandably feel like their pet is a member of the family. A 2005 study found that 87% of dog owners surveyed viewed their dog as a family member, and as many as 15% of them would pay over £10,000 to secure custody of their dog on separation from their partner. So it's clear that pet ownership is a sensitive and highly emotive subject that perhaps doesn't sit very comfortably within the framework of financial remedies law as it currently stands. As Katherine alluded to, because many people feel such strong emotional ties to their pets, unfortunately, the family pets can sometimes be used as a bargaining chip or a bullying tactic in an effort for one party to obtain a more favourable settlement over the other. In some other cases, it can lead to one party flat out refusing to settle or being very reluctant to settle. One of my other colleagues in Chambers had a case like that very recently, where her client was unfortunately so heartbroken that her former partner had taken the family dog with him and that she simply didn't want to settle. And perhaps that's something that is quite understandable. A further layer of nuance, if you like, can be added in cases where pets have significant financial value. So that can be seen, for example, with pedigree dogs or dressage or racehorses. And those types of animals will frequently feature on asset schedules and may be ascribed significant monetary value. There may be arguments over breeding rights, sharing in prize money and other financial gain from any offspring or future earnings associated to that animal. Looking at what other jurisdictions are doing at the moment, it's clear that the treatment of pets and their status in family law in England is arguably somewhat behind other countries. And it seems that there are sort of two different ways of thinking about this issue. One is to apply pure property law principles arising from the status of pets as property. So as Katherine said, that's really looking at who has the better claim to title, looking at things like receipt of purchase or adoption certificate, who pays for the vet bills, the pet insurance, the pet food. A different and alternative approach is to look at the best interests of the animal. In other words, welfare considerations akin to children act proceedings in this country. And globally, some other countries are moving away from a strict application of property law principles and towards a slightly more modern welfare influenced approach. So we can see that happening in countries such as the USA, Israel, and Switzerland. There's a few case law examples I'll just touch on very briefly. So in the Appellate Court of New York, in the case of Raymond and Lackman, a decision was made to reverse the lower court's decision to award sole ownership of the party's cat to the claimant under a straight property analysis, as the court decided the cat was a feeling individual who had lived, prospered, loved, and been loved solely by the defendant. Very sweet. A similar case, court in Virginia also decided the happiness of the cat took precedence over a former couple's property rights, and that's Zovko and Gregory. Factors that might be relevant to a judge's determination in those jurisdictions that are moving towards a welfare-based test are things like lifestyle considerations. So does one party work full-time and therefore may not have sufficient time to properly attend to the pet's needs? What are the surroundings like for the animal? Is there a garden? Is there enough space? Will the animal be living in the city or the countryside? Will the animal be kept in familiar surroundings that they're accustomed to? Also, attachment to the individual is considered to be quite important. So looking at who has the strongest bond with the animal, who does the animal spend the most time with? And also, will the animal be kept with the children of the family? In some cases, courts have commissioned expert reports to consider what is in the best interests of the animal from a purely welfare perspective. And it will be interesting to see if there's increasing use of such expert reports in future. And I think looking at some of those other jurisdictions, it seems there is ample scope for potentially reforming this area of law and to move away from that property test and towards a welfare-based test. But I think that's all myself and Katherine are going to say on the subject for tonight. However, if you are interested to hear a little bit more about this topic, specifically relating to financial remedies, then we will be doing a more comprehensive seminar on the 30th of November. So do sign up to that if that sounds interesting.
I believe that's over to me now.
I think that's right, Paul. We were going to hear from you next.
Thank you. Well, good evening, everyone. Well, as we've heard, the catalyst for the discussion this evening was, amongst other things, the recent publication of government statutory guidance into controlling and coercive behaviour, which has confirmed that harming or threatening to harm and indeed giving away pets is likely to amount to a crime of controlling and coercive behaviour under Section 76 of the 2015 Act. And so to that end, I suppose I took a slightly nuanced approach and started to think specifically in the context of property and animal welfare perspectives, what factors might act as an impediment to a victim of controlling and coercive behaviour from extracting themselves and their pets, of course, from very dangerous environments and situations. Those factors might, of course, include legal and financial ties to their home and as well the risk for the welfare of their pets. So a victim of controlling and coercive behaviour might, for example, be a party to a tenancy agreement under which they have liability to pay rent and discharge other obligations in respect of the property. And that situation would be additionally complicated, of course, if the victim was a joint party to the tenancy agreement with the person who's exercising controlling and coercive behaviour. So what can be done in that situation? If the tenancy is a periodic tenancy, then the victim can simply serve notice on their landlord terminating the tenancy. That's something that can be done by any of the tenants, including the victim, unilaterally. It doesn't require all of the tenants to be in agreement. And all that needs to be done there is service of notice to quit. Minimum notice period is 4 weeks, or if the period of the tenancy is longer than that, then equal to a period of the tenancy. What if the tenancy is not periodic? What if it's within the fixed term? Well, in that case, in the absence of a contractual break clause, there's no right to terminate unilaterally. Termination can be effected by a mutual surrender of the tenancy, but that requires the consent of all the parties, including the person exerting controlling and coercive behaviour, who is likely to be unwilling to cooperate. If the victim feels comfortable doing it, then he or she can speak to the landlord. And one possible option in that situation is for the landlord to seek to serve notice under Section 8 of the 1988 Housing Act, or Section 83 of the 1985 Housing Act, as the case may be, terminating the tenancy on grounds in these situations of criminal or antisocial behaviour. That will, of course, require evidence. How about if the victim owns the property that they're fleeing from? They might have ongoing mortgage obligations. They can't simply terminate those obligations in the same way that they might be able to a tenancy agreement. They might need to sell the property to redeem the mortgage. And that's a situation that would be additionally complicated where the victim owns the property, again, jointly with their abuser. The first thing that I would suggest the victim should immediately look to do in this case is serve notice severing any joint tenancy. So in the unlikely event of the victim's death, the property passes to his or her estate and not the estate of the abuser under the rules of survivorship. Next, they should approach their bank. Lots of banks these days have policies and procedures in place to give victims breathing space in these types of situations. They can include payment holidays and changing products from capital repayment mortgages over to interest-only mortgages, which would reduce, if not extinguish, payments, at least in the short term. And lastly, of course, if the property needs to be sold and the person exerting controlling and coercive behaviour is not cooperating in the sale, then it may be necessary to bring order for sale proceedings. What about then finding accommodation on short notice that will allow the victim's pet? Because, of course, as we've heard today, unless the victim is able to take the pet that's being threatened with them, it's very unlikely that they're going to leave the property. Currently, landlords have an unfettered right to prohibit pets under the terms of tenancy agreements. But that is something that the government is endeavouring to address. In January 2021, the government published a standard form tenancy agreement to help renters with, quote, well-behaved pets. And the standard position under that model tenancy agreement is that landlords have to opt out. So the standard position is that pets are allowed and landlords have to opt out and they have to give good reasons for opting out. And the government has encouraged landlords to use this model agreement, but it is currently, however, only suggestive. A white paper published on the 17th of June this year seeks to address that, though. You may have heard of it. It's entitled A Fairer Private Rented Sector. And that bill, amongst a whole host of other things, observes that, quote, domestic pets can bring joy, happiness and comfort to their owners, as well as supporting their mental and physical well-being, included through challenging times. And to that end, the paper proposes to, quote, legislate to ensure landlords do not unreasonably withhold consent when a tenant requests to have their pet in their home, with the tenant able to challenge a decision. The white paper also proposes to make changes to the Tenant Fees Act, which currently prohibits any fee by the landlord in respect of pet insurance, and that has been seen as prohibitive, as of course where landlords can't charge their tenants for pet insurance, they're less likely to be willing to allow pets. So pending those legislative reforms, there are charities that currently provide temporary foster arrangements for pets for the victims of domestic abuse, whilst they find safe, secure and pet-friendly accommodation. And I know that the Dogs Trust and Cats in Crisis are two of the charities that do that. So just to recap, if the victim's renting, serve notice ending the tenancy. If it's within the fixed term, ask the landlord for a surrender or take steps to end the tenancy his or herself. If the victim owns the property, serve notice severing any joint tenancy ownership. Ask the bank for a payment holiday or to change over to an interest-only product, and consider issuing order for sale proceedings. And as regards seeking alternative accommodation, look out for those changes in the law mandating landlords to take pets. And in the meantime, think about charity foster schemes. That's all from me.
Thank you, Paul. I think Richard was going to.
That's right. I'm Richard Furniss, and I practice in personal injury and clinical negligence, but also in related professional negligence. I've done quite a lot of veterinary surgeons' negligence and solicitors' negligence arising out of failed PI or clinical negligence litigation, etc. And I'm coming at it from that perspective, and Marcia told me I'd be the villain of the piece tonight, because personal injury law isn't primarily about the welfare of animals. Rather, it's about mostly humans being injured by animals. Animals are chattels as far as personal injury law is concerned, and they're dangerous chattels. Let me just state the law simplistically in a couple of sentences. You will note that there are different definitions in different acts. You heard Ed describe or define what animals were according to one act. The Animals Act is a bit different. If I own an animal that is not commonly domesticated in this country, and Ed explained what that meant, when fully grown could cause severe injury, if not restrained, then that's an animal that's a member of a dangerous species. So if I own a venomous snake and he escapes from his tank and bites and injures you, then you've been injured by a dangerous species and I am strictly liable to you. In other words, you don't have to show that I was careless, negligent, or even that I ought to have known that it might injure you if it had escaped. On the other hand, if I own a domesticated animal, and my experience is mostly injuries caused by horses, dogs, and cows, and I'll come back to that, you have to show three things. You have to show that the injury was of a kind which the animal was likely to cause, bite from a dog, a kick from a horse, and a trampling from a cow, for example. Then you have to show that the injury was due to characteristics of the animal, which are not usually found in animals of that species. So a dog that's prone to biting people and has a history of it would be an example of that. Or characteristics that are not usually found except in particular circumstances. And I'll come back to that, and that's often the reality of claims brought against owners. And then thirdly, you would have to show that those characteristics were known to the person in charge of the animal. And again, that's the keeper, not the owner, the person in charge at the time. I can recall dealing with 2 fatal accidents and at least 4 that I can think of, serious injuries caused by cows stampeding. And what commonly happens is that someone walks a dog through a field, quite possibly legitimately through a public footpath, and there are cows with calves on the other side, and those cows will run and trample the dog and the dog walker, causing serious injury or death to both. The injured person may have had no idea that cows would behave in that way. And if you talk to people who haven't come across this before, they're often very surprised that you can be attacked by a herd of cows. But of course, the owner of the herd almost certainly ought to know that one of the herd's characteristics would be to protect their young in that way. Now you're asking yourself, what has this got to do with animal welfare? And my answer to that is that by imposing a duty on human owners of animals, you are likely to encourage the owner to pay more attention to the animal's welfare. After all, when a herd of cattle stampedes, they're not doing it maliciously. They're doing it because they're extremely distressed and want to protect their calves. A farmer who has caused this kind of accident, and farmers who might otherwise potentially cause accidents like this, can be encouraged by insurers in particular and by publicity to recognise the duty. You can't keep your cows in a field where there's a public footpath running through it where dogs might be walked. Put them somewhere where they won't suffer that distress of feeling threatened, or at least put a sign up saying, don't walk your dog through here, at the moment they're just carved. And similarly, with veterinary negligence, the welfare of animals is promoted by the duty to take care, and we find that often. Let me turn to a slightly different point, to the circumstances where an animal itself is injured. What happens if both you and your pet in the back of the car are seriously injured in a road traffic accident caused by another driver? I can recall several times when I've been advising the human on general damages for pain, suffering, and loss of amenity. I tell them you've been seriously injured, you're going to get 75,000, say. And then the question comes, how much will my dog get for the pain and suffering that's been caused to the dog? Well, you have to let the client down. As you've heard, those animals are chattels only in English law, and in general, your pet dog has the same legal status as, did you say, a chair, a fridge, or a painting? And that's the long and short of it. Damaged in the back of your car. So if your pet is killed in a road traffic accident, what you are entitled to is primarily the monetary value of the pet. And it's very, very hard for people to stomach when you explain that. But I do think that sometimes animals have rather more value and status in one respect. If your fridge or your chair or your computer or the car itself is written off or badly damaged so that it would cost more to repair than its value, you will recover the value, go and buy a new one. But if your dog in monetary terms has a value of, well, costs a couple of £1,000 today, and you have to spend, say, £6,000 on vet's fees to make him well again, then you are likely to recover those fees. No one is going to suggest you have to replace the dog. So that's one aspect where good sense prevails. But otherwise, as I say, I'm the one that's saying that animal welfare law has a limited place in the law of personal injury. You have heard from others that the law is developing in different aspects of the law. And we'll see in years to come what happens as the sentience of animals becomes more recognised by the law. Thank you very much.
Thanks, Richard. Thanks, everyone. Just a couple of questions come up, if I can put these out. One of them from Twitter. This is about microchipping animals and how relevant or otherwise that is in proving ownership. I think that is that for you, Ed, at all?
Yes, I can deal with that. It's a microchipping of dogs, England regulations 2015, I think. It governed the chipping of dogs. And under those regulations, which I don't have to hand in detail, but I do know that they cast a duty on a dog owner. Any dog owner out there listening to this will know this. To the keeper of the dog must get the dog chipped. Now that's the duty on the keeper. And the important thing about this, this covers civil and criminal law. This is another aspect which covers civil and criminal. There are criminal offences under those regulations which are not straightforward. And in fact, I do know, I won't go into great detail about them, but essentially the chipping of a dog is the duty, like I say, is cast upon the keeper, but that is not the same as the owner of the dog. And I've gone on at some length about the common law ownership of animals, and dogs, of course, are domestic animals. Probably the most supreme example of the domestic animal. But the owner of that dog, of course, might have bought it under the Sale of Goods Act, bought it from somebody, but then given it to a friend as a keeper, or let it remain with the partner, say, as a keeper of that dog. And it would be the keeper of that dog that would be obliged to chip it. And indeed, the subsequent keeper, I think it's if a keeper then gives the dog or hands over the dog to another keeper, I think it's the new keeper of the dog has the obligation to chip it. But I think the criminal offence is not straightforward, because I think it's the straight failure to chip it is not necessarily a criminal offence. It's I think it's when it's handed on, and I don't have the regulations in front of me. But the important point is the chipping of a dog is not necessarily the only indicator of ownership of the dog, because indeed it's probably just evidence, because somebody may have not updated the chip, for example. So the new keeper, often the keeper, of course, will be the owner as well, but it doesn't follow that they have to be. So the police might find a stray dog, and they might think that the owner must be the person who is mentioned by the chipping company as being the holder of the chip, or the person named in the chip, but that might not be true in English law. Now, I've had experience in cases where the police have thought that, but in fact they don't recognise the fact that, in fact, someone else might be the owner and have a better claim to it, because they can prove that they bought that dog, and they have all the paperwork to prove that they bought it. Anyway, in a nutshell, that's it. Does that answer the question?
I think it probably does, quite comprehensively. I think we've only got time really for one more last question. This question from Richard. Richard, I'll read it out to you so everyone can hear it. A person suffers a diagnosable psychiatric injury caused by witnessing the death or injury of an animal, e.g. a pet. Can you envisage a successful personal injury claim in such a scenario?
The answer to that's no, I'm afraid. And the answer is the Hillsborough case of Alcock in the House of Lords, where for policy reasons, the House of Lords strictly limited the class of persons who can sue. And basically, you have to have a relationship which is the equivalent of that between spouses or parents and child. And you have to witness that death or serious injury or danger and suffer a psychiatric injury result in order to recover. Now, that's a very simple way of putting it, but I don't think that witnessing a pet injured and developing a psychiatric injury would get anywhere close to fulfilling the Alcock criteria, I'm afraid. Alcock, of course, is absolutely ripe for being distinguished.
Ah, well, you might get instructed there, Richard.
But I think there's a way to go before before we go that far, I'm afraid.
All right, well, look, guys, it's almost 6 o'clock. I think we should close up. Thank you all, and thank everybody for attending and asking some interesting questions. If you want to look at this again, as I say, it'll be on the website probably by about Thursday, and look out for our next webinar, which is probably going to deal with either farmed animals or judicial review or something like that. So thank you for joining, and enjoy the rest of your evening, everybody. Bye-bye.
Thank you.